In earlier, my lord, some
Okay, fine.
additional document is yet to
As prayed
furnish,
for-
I will buy additional affidavit, my lord, because earlier no documents was.
Please wait. Just wait for the
What?
turn. I shall accommodate you, but let us pass some effective order. Yes, please wait for the turn. Next.
Lordship, I beg to mention item number 4, Lordship.
Item
Number 4, Lordship.
4 also counter affidavit. Wait for your turn. The item 1, with the first few items, why are you mentioning? Just wait for your turn. Whatever accommodation is required, this court will certainly, if possible, will give you. Yes, next.
Yeah, please, Your Lordship. Item number 34, I am praying for adjournment, my lord. In this matter, we have to take steps for service of notice. That we could not take, my lord.
34 is an order matter.
Yes, my lord.
Then you wait.
Review-
Next. Wait. Don't make a mention of the order matter. Yes.
Order goes to item number 1.
Yes. Should I dismiss or you will take fresh steps?
Your Lordship, actually, I have taken a step, but unfortunately, it not reflected.
Yeah, so what is to be done?
Technical difficulties,
Hmm?
maybe technical difficulties, Lordship, was not shown. So direction may be given to the registry to verify, Lordship.
You have taken.
I have taken.
Mr. You are Mr. Saikya.
Yes,
Mr. M. Saikya, Learned Counsel, appearing for the petitioner, submits that though the aforesaid matter has been listed in the column orders for no steps within quotes. However, he has taken steps by, yes, give me that number slip.
your Lordship, this is a
By
case
tree.
status.
By Vide so and so, whatever that document number to DD body metric, Vide so and so. Let registry verify and relist the matter after a week on a date to be fixed by the registry.
Then liberty may be given to take if
Next.
required.
No, you are submitting,
Taken,
which is
yes.
your submission.
Yes,
If you wanted that liberty, that should have been the first submission.
No, if required.
Yes, next.
Supplementary list, order impleadment of party, item number 46.
Impleadment.
My lord,
Objection.
Lordship, we have been, that has been on record.
It's not on record.
It's on record, Lordship.
What is the objection, Mr. Betala?
Lordship, there are 2 points, Lordship. First thing is that, Lordship, the list of the successful candidates who were called for interview was never published. Second important ground, your Lordship may kindly have the eye at page number 25.
Now, the
Pursuant-
proposed respondents are who?
Lordship, there was a list of candidates who were called for interview, Lordship. Even my name was not there. I approached this court. This court allowed me to appear in the interview, Lordship. Now she has been canvassing the issue that I want to project something before this court and Lordship on that.
So maybe,
Yes.
you see, she may not be a necessary party, but she may be a proper party.
That I leave to my Lordship. That objection-
More the merrier. Why? We should not allow someone if somebody wants to come and say something. So you have filed this impleading to implead yourself.
Lordship.
You are one of the
One of the
candidates
candidate, Lordship.
who had applied
Yes, Lordship.
in the selection which is under challenge.
Yes, selection.
Heard Mr. D. Mahanta, Learned Counsel, appearing for the writ petitioner. Also heard not writ petitioner, applicant. Applicant also heard Mr. H. Betala, Learned Counsel, appearing for the respondent stroke writ petitioner. Stop. Anybody else?
Hearing responding 3 to 6.
MS
P. Upadhyay.
P. Upadhyay for respondent numbers
3 to 6.
3 to 6. Stop. By way of this application, the applicant is seeking impleadment of herself.
Herself. As partition 7.
Impleadment of herself. Where do I find her name? Dr. Sumanna so and so. Page 3 Paba. As a arrayed respondent. Stop. Yeah, as an arrayed respondent in WPC number 1381/2025. The brief facts of the case is that the writ petitioner challenged the selection to the post. What is the post?
Post of librarian.
To the post of librarian as advertised,
12/8/24.
as advertised, Vide Assam University, no, as advertised, Vide Employment Notification Number 2 of 2024, dated 12/8/2024. Stop. Hmm?
Lordship, at page number 23, para number 2, it has specifically mentioned.
It's all right, Mr. So-and-so, learned counsel appearing for the applicant submits that since the applicant has appeared before the interview board pursuant to the calling letter and participation in the subject selection process, her presence is essential for an effective adjudication of the issue involved in this writ petition. Stop. Mr. So-and-so Betala opposes the prayer of impleadment and submits that since she is not, what did you say? She
Not a candidate who has been selected. Lordship.
She is not a candidate who has been selected in the subject selection process. Any submission, any opposition, so-and-so submits that she has received no instructions to oppose the prayer of impleadment. Heard peruse Koiriba at length. Apt to refer to the relevant paragraphs of the impleadment application, which reads as hereunder. Para 6, 7, 8, 9, 10, 11, 12, 13, 14. To 18, huh? Directly 18. Reading of the aforesaid averment, it appears that the presence of the applicant is a proper, though may not be qualified as a necessary party in the instant writ petition. However, she cannot be termed as not a proper party also. In view of that, her presence is essential for effective adjudication of the writ petition. Accordingly, the impleadment application stands allowed. It is hereby provided that so-and-so be impleaded as party respondent number 7 in WPC number 1381/2025. Let an amended cause title be submitted to the registry for doing the needful. IA stands disposed of.
Deeply over.
Amended, Lordship, amended cause title by petitioner. Lordship.
By the petitioner. Hmm? Yes, in 4, somebody was seeking for some time, I think.
Yes, Lordship.
Yes. Yes, Mr. Barthakur.
Judgment by your lordship, my lord, where due to lack of
Delay.
time, it was dismissed. I have the copy of the judgment.
Judgment to law. In this case, petitioners,
Have not challenged the waiver.
no, husband, father, what?
Son's father died, Lordship.
Father.
Yes, father died.
Father. When?
2009.
2009. And when did you apply?
Sorry, Lordship, but I don't have the brief today, Lordship.
Why?
So, Lordship, senior is out of station, Lordship,
When is your senior coming back?
on 25th of August, Lordship.
Heard so-and-so learned counsel appearing for the petitioner, also heard so-and-so. Ms. So-and-so submits that since her senior, Mr. DC
Mr. DCK
Hazorika is out of station, therefore the matter be accommodated for a week. Mr. So-and-so submits that this matter, the issue involved in this matter pertains to the delay of several years in seeking compassionate appointment, and hence the writ petition is non-maintainable. MS So-and-so submits that she has no brief to assist the court. In view of the fact that the learned counsel is appearing without a brief, the matter unhesitatingly has to be adjourned at a date after.
Obliged.
Please understand the gravity.
Yes, Lordship.
You are here before the court without a brief. Even if you have to make a mention, please ensure that the brief is in your hand.
Yes, Lordship.
Item number 5.
May it please your lordship.
Impleadment.
Yes, lordship.
Yes.
This, I for impleadment petition as per, order of this honorable court, the order is at page 6, lordship.
No, but that IA is not yet disposed of. Disposed of.
Sorry, your honor, this is admission matter, admission of the facts.
In this matter, correction of date of birth after 32 years.
Hmm.
However, our record says, whatever is
32 years.
32 years.
Pagant.
Yes.
Pagant.
Yes. Whatever he only paying for a correction of any admit card.
But where is the petitioner?
We have filed affidavit, my lord.
BTC, anyone appearing?
This case is this, lordship.
BTC?
BTC not, my lord. BTC party is
This is his name reflected or not? This is item number
5.
5.
BTC party
Yes.
as well as 4.
And names not shown because last order says although instruction was required to be obtained with regard to the prayer for correction of the date of birth of the petitioner, it is submitted at the bar that it is the BTC authority to look into the matter. Since the BTC authority is not a party respondent, is granted a week's time to file. Yes, what happened to that impleadment?
Impleadment petition has been filed, your
Where is it? Huh? This is that matter only. Why you thought it was not your matter? You got confused. All right, I'm allowing this impleadment.
District limited education officer, DTD is a party, that's for number 4.
Hmm.
And 5 is a block limited education. Of whom they want to implead, director.
They are bringing the BTC number 1 and number 2 director of education. Third MS,
MJ Begum.
MJ Begum so and so and Mr. TC Sutia so and so. By way of this application, comma, the applicant is seeking impleadment of the BTC through the principal secretary and the director of education BTC as arrayed respondents in WPC number 5769 of 2021. Pertinent that in WPC 5769 so and so, this court on 23/6/2025 upon a submission being made at the bar that it is the BTC authority to look into the issue involved in the writ petition, i.e. correction of the date of birth of the petitioner, comma, accommodated the writ petitioner to file necessary application to bring the BTC authority on record. In view of the aforesaid opportunity, the present impleadment application has been filed to bring the BTC authority on record. Perused the averments made in the impleadment application as well as the grievances raised in the grievance of the writ petitioner canvassed in the writ petition, comma, it appears that the presence of the BTC authority is essential for effective adjudication of the writ petition. Stop. Accordingly, so and so and so and so are impleaded as party respondents number 6 and 7 in so and so. Let an amended cause title be submitted before the registry for doing the needful, disposed of.
Person is going to retire in the month of September, Your Honor. Next that may be fixed, Your Honor. Within
Uh,
a week.
you first file it. Yes.
Bless you.
Number 6.
Meta may be password for the timing.
Number 7.
I to dispose, isn't it? Yes.
Appearing for the elementary education, I'll be filing my affidavit. So I already have set for sign.
All right. As prayed for by Mr. A. Fukan, learned Standing Council Elementary Education, relist the matter after 2 weeks to enable the Elementary Education Department file return in the matter.
Item number 8.
Some audit report was required. Yes,
required.
Yes,
Mr. Das.
yes. The thing is that on the last occasion, the court asked me to produce instruction as to whether the accounts have been completed or not. My instruction is of the month of January.
So you want the updated instruction?
Yes, probably because by
All right, you have your up-to-date
Yes,
instruction. Mr. Sharma, let him.
I am concerned, but my only grievance is there. Yeah, according to the additional affidavit, page 95, there says auditor already appointed.
So that's all right. He has to give the up-to-date instruction.
Audit.
All right.
Along with
Mr. Das, you don't have to give it.
audit report.
Mr. B. Heard Mr. B. Sharma, learned counsel for the petitioner, also heard Mr. S. Das, learned standing counsel.
yes, telling
Standing counsel, finance department.
no ASIDC.
ASI.
I'm small industry.
Sorry, ASIDC. Chalia is there or anyone finance? And Mr. So-and-so for finance, huh? Mr. Das submits that though in terms of the order dated 3/12/2024, the ASIDC authority was required to place the up-to-date audit report.
Yes.
However, the instruction which he has received today or when
I received on 6th of January.
received is not up to date and is only up till
6/1/2020.
6/1
2025.
2025. Let so-and-so obtain the up-to-date instructions and place the same before the next date of listing. Relist on such and such date. Date did you?
Highly obliged.
Item number 11.
Yes.
Lordship, Lordship, there's an order by which they were asked to regularize the
Area salary.
Lordship.
Which
yes.
order?
Justice Nayar's order.
Miss Counsel,
I'm-
I am not
I'm
asking
so
about
sorry,
the
I'm-
name of the judge.
I understand.
I'm asking the date of the order.
Lordship,
Please refrain yourself from saying the names of the coordinate benches. Point out the order date. Which is the order date? You want this court to look into it?
No, Lordship, I'll.
Yes, 8/4/2025. 4. Yes, who's appearing for the elementary education department? Heard so and so, none appears for the elementary education department on call. Relist tomorrow.
Item number 12.
May not like to pick up the.
All right, not by me. Yes, Mr. Fukan?
I'm in this matter.
Yes.
Item number 13.
Yes.
Time being made.
Lordship, in this case, draft affidavit has been sent for pending lordship, so 2 weeks time may be granted. 2 weeks time may be granted.
She wants some time to file the affidavit. She says the draft affidavit is already sent for vetting.
I'm not in this case, I'm just waiting for my own. That's.
You wait for some time. Yes.
Okay.
Item number 14.
Yes, regularization of service.
My lord,
Counters filed, returned.
no, my lord,
Who is appearing? PHE.
my lord, similar order was hearing.
PHE. All up piece of money, neighbor. Get hold of someone from PHE if there is a similar order.
Item number 16.
Matter relates to the releasing the pension lordship as well as area salary. Petitioner retired in the year 2020 was
20?
lordship, 2020, on 13/9/2020.
Your retirement benefits or what pension?
Pension as well as some area salary.
Nothing has been given.
Nothing has been given.
Yes, why no affidavit has been filed?
One affidavit has been filed, specifically from respondent number 5, that is the lordship deputy district commissioner.
Why is the High Court also a party here? This is an employee of the High Court.
This is my one typography.
Huh?
You are not the commentator is your lordship, this,
Then why?
This should be office of the chief judicial magistrate lordship. I'll correct by filing additional evidence.
So who is the concerned respondent who has
We
to
have
file
filed-
return?
Filed one affidavit lordship, basically, my I say page number 47 lordship, with the affidavit.
Yes,
May as a seller to read it or lordship.
yes.
Could not be dispersed due to non-receipt of fund at the major head, so and so, also request was made by the same letter to the. to
One
export-
second. 40?
7.
Yes.
Could not be
Which
dispersed.
part are you reading?
From the very beginning, lordship.
Could not be dispersed, yes.
Due to non-receipt of fund under major head account so and so 2014. Also request was made by same letter to accord necessary sanction for approval funds under head of account of.
No, request was made to whom?
Request.
Next that 60 page.
To whom? To whom?
To the joint secretary, judicial department,
Judicial.
once it was requested to accord necessary sanction for allotment of.
Then what happened?
After that lordship, judicial department dispute in which it was mentioned that there is no budget provision under 12 area salary heads of account so and so. 2022-23. Also, in reply to the letter of judicial debate, it was informed by the DC Dima Hasao that certificate as sought by the department for release of salary could not be issued by this office as the incumbent so and so. He had been drawing his salary under the head of account so and so, which is already being handed over to the CJM Haflong, and the online salaries details are no longer available with this office. A letter from the Joint Secretary of Government of Assam was received seeking proposal once again for sanction under regular salary.
One second. This letter was received from
LR lordship.
Judicial Department.
In respect of.
Was received seeking proposal once again for sanction. Yes.
There is and also to certify that there is surplus budget in the regular salaries here. Okay. And if area salary sanction from the current salary budget, then it will not hamper the drawal of regular salary officer and staff from the DC office Dimahasa. In this regard, proposal was again submitted for sanction under the head of salary 23-24 for payment.
No, but then it seems that the second time proposal was sent. However, the certificate as sought by the Judicial Department could not be submitted as there was no surplus budget in the FY so and so. What does that mean? You see, it appears that because of these technical issues, the pension benefit has not been released. That can't be also. From 2020, this person has retired until now we are in 2025.
I will be allowed to get some updated.
You get your up-to-date instructions because this affidavit is neither here nor there. It is only indicating how many times you have sent for proposals, how many times it has come back. But something concrete must come. You must come up with some solution.
Some logical.
You cannot just simply say you've been forwarding it. Yes. Your name? As prayed for by so and so, relist to obtain up-to-date instruction as regards the status of the pending area salary as claimed in the writ petition. How much times?
2 weeks.
2 weeks. Huh? Give a date after 2 weeks on such and such. Pension and area salary. As claimed, so everything is included, Mr. Khan. Give your appearance.
Item number 17. Item number 18.
Yes.
An affidavit has been filed.
Health. Affidavit has been filed. Yes, you want to file a rejoinder?
Yes, Your Lordship.
Okay. As prayed for by Mr.
As Gautam, Your Lordship.
As
Gautam.
Gautam, learned counsel appearing for the writ petitioner, relist after 2 weeks to enable the petitioner to file rejoinder against the affidavit in opposition filed by the Health Department on 3/3/2025.
3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025. 3. 3. 2025.
Item number 19.
Yes, Mr. Chaudhary?
Yeah, may it please allow. Well, this
Suspension
actually,
matter.
it covered, my lord. It's covered by 2024 4 GLT 1007.
Review or no review, or review after
No
expiry?
review.
No review.
Well, the facts are on a very narrow compass.
Yes, it
If the
seems
law will kindly take note of
30/12/23 suspension.
Exactly.
Show cause notice on 1/3/24.
But
Then it
we-
expired on 29/3/2024,
Yes.
and on 27 there was an extension.
Yes, no, but
Correct.
28/6/24.
28.
6 review was done.
Okay, because I found my handwriting. I must.
Yes.
It may have come before this
Yes,
code. Yes,
yes.
it did come on 12th of August.
Yes.
So,
So these are the dates, my lord. So therefore,
which is that order?
yes, sir.
Yes, Mr. Barua.
Here, as part of affidavit lawsuit on 28/8/2000.
After the expiry, Deepak Mali.
Deepak Mali. I'm relying on an order of this honorable court, my lord.
Yes.
Deepak Mali also I brought it.
But I think basically Deepak Mali's
Yes, sir,
ratio,
Deepak
right?
Mali and my lord, that Ajay,
No, that is your first one.
Yes.
But in Deepak Mali, I think that extension part has been
yes,
uh,
para 11.
correct.
Yes, yes.
If I
Para 11.
recollect, it has been clearly said that after expiry, review done is also of no good.
Meaningless.
It will be reinstatement.
Para 11. my lord.
Subsequent review and extension, in our view, could not revive the order which had already become invalid after the expiry of 90 days from the date of suspension.
Yes.
And in the coordinate bench, which paragraph?
I think 27 and 28, my lord. I have indicated there. There are other orders also. my lord.
You need not.
Yes, yes.
This office memorandum is included, is here also, no? The 4/2/2020.
Yes.
But in your case, the charge sheet has been issued now.
Yes, yes. As it was issued, my lord, on 1/3,
On when?
1/3, 2024,
1/3/2024.
3/2024. Show
But-
cause.
No, that is a show cause. What about?
Show cause.
Okay.
One part of Ajay Chaudhary was complied with, but the other part was not. There are two parts.
The extension part.
Yes.
Reasoned by,
Yes.
that is what you are
Yes,
saying, right?
yes. And in their affidavit also, they have passed that, annexed that order.
But this,
Whereby-
which you are trying to, which paragraph is, because this is talking about the extension.
I think, my
part.
lord, it speaks of first part and second part. Can I just find out the
I
part?
think 29.
Yes.
I think, right. So in the show cause notice of 1/3/2024, there is no reasoned order of extension.
No. By their own showing, my lord, at page 108, it was issued on 28/6/24.
Right, I'll take those dates. Mr. Barra, you have seen this order, para 29. I think it is covered.
Yes, covered.
Lordship, I will be allowed to examine that part, Lordship.
2 o'clock?
Yes, Lord.
Mr. Chaudhary,
Yes.
you need not be here.
Yes,
Junior.
Yes, yes.
You have this
In
copy
fact,
or
my
not?
lord,
I don't have that.
In fact, I'll give a copy.
Ask your
In
junior.
fact, my lord, we are talking of Ajay Chaudhary. My lord, our Assam government guidelines are already there from 1972.
Before, yes, in that, I think in that
manual of
manual,
department instruction.
yes. I have kept these 2 decisions here.
Yes,
If
yes,
you
yes.
want for photocopy, you can
No,
take
no,
it.
my lord, I'll give a copy.
At 2.
আমার 19 judgment for copy এটা দিই।
Item 20.
You want some more time? As prayed for by Mr. N. Upadhyay, Learned Counsel, appearing
For 1 and 3, Lord.
for the respondent 1 and 3, relist after 2 weeks on a date to be fixed by the registry to enable the said respondent file return in the matter.
Obliged, Lord.
Obliged. Item 21.
Yes, AO ma'am,
2 days time.
2 days, 2 days time for filing return. More 2 days. It's all right. Heavens will not fall in 2 days. Yes.
Receive the copy of the affidavit if they are filed by law.
Huh?
Today was the date for submission of.
It's all right. They're seeking for 2 days. This
days,
court will
only
give
for
them that 2 days. As prayed for by MS, yes, your name?
MM Kotoki.
So and so, relist this matter after 3 days. That did you? Rupak? Moitri after 3 days. On such and such date to enable the respondent file return as assured before this court today.
Okay. Item number 23.
Yes, Mr. Chaudhary, regularization.
State has not filed their affidavit.
Yes, are you planning or you are giving up?
No, Lordship, we've already sent the affidavit for vetting.
So how
Lordship,
much
the
this
sworn
was
affidavit-
in fact in the last order
Yes,
also it's
Lordship.
reflected that was in the month of June.
Yes,
Now
Lordship.
we are almost you may say we are in the middle of August.
Lordship,
Yes.
I'll take up the matter and Lordship, I'll
All right.
file the affidavit.
Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. So and so, Learned Counsel for the petitioner. MS also heard so and so. MS so and so seeks further
2 weeks, Lordship.
2 weeks. Further 2 weeks time to file the return in the matter. Prayer is not opposed. Released after 2 weeks on a date to be fixed by the registry.
Highly obliged.
Item number 24.
Yes, AO.
Lordship, affidavit, I have received the copy of the affidavit. I will be filing it within a week.
You have received the
Yes,
copy of the affidavit?
Duly sworn affidavit, I have received from
Okay.
Silchar. By
Uh,
tomorrow, I will be filing.
All right. Heard Mr.
See,
C. Gogoi, Learned Counsel appearing for the writ petitioner. Also heard Mr.
SP Choudhary.
SP Chaudhary, na? Chaudhary Learned Counsel appearing for the respondent.
Respondent.
Mr. Chaudhary submits that a signed copy of the affidavit has been received back in his office and the same shall be filed within
2 days, Lordship.
a period of 2 days from today. In view of the aforesaid assurance, a relist after a week on a date to be fixed by the registry.
25.
No, your lordship.
Yes.
Find out though I'm the standing counsel of WMD department, no copy was served to me while filing this writ petition. So lordship, I have come to know this petition was filed. I need 4 weeks.
You are a party also.
Yes, madam. I am.
Just give her a
I
copy.
have copy by today, and as regards, your Lordship,
Give us 1 week time to file a petition.
Yes, we will give everyone time, not to worry.
as per the order, Lozima order, Lordship, on 13th to 25, service of respond number 7 has not been completed. We'll take fresh steps of respond number 7 and if the Lordship allows, we'll take that service.
Okay. And except 7, everybody else is represented?
Yes,
All the others.
All of
Okay. Heard Mr.
AI Ali, Your Lordship.
A. Ali.
AI Ali.
A.I. Ali, learned counsel appearing for the petitioner. Also heard MSMD
Bora.
Bora, learned
Standing Council, WMD Department.
standing
1 and 4.
counsel,
WMD,
so-and-so department within bracket, responding numbers
1 and 4, my lord.
1 and 4. Huh? And MS
Kolita.
and Kalita, responding number 6. Anybody else? 2. So 1, 4, 6, 2 is done. Now who's for 3?
So the 3 is the Assam Board of Wakaf.
They will have to take steps, my lord. Because it's represented as
Yeah, on
chairman.
the first day itself, someone has appeared. Lordship.
So
Chairman
who has
have to take
appeared?
steps.
Who has appeared and taken steps? I mean, extra copies, who's received? For 3, anyone received? Mr. Bora had accepted notice for our numbers 1 to 4.
Deepam Bora, I think junior government
Hmm.
has accepted, but no.
Have no extra copies.
No, but are you, Miss Counsel, are you appearing for respondent number 3 or not? Who is appearing for R3? Because on the first day, S. Bora had accepted notice for all. Mr. D. Bora, one Mr. D. Bora. Yes.
As far, I don't think Lordship will be appearing for the chairman, Lordship.
So then you take
I'll take prescription.
Mr. So-and-so submits that in terms of the Lawazima, in terms of the office note dated 3/6/2025, he may be allowed to take fresh steps in respect of respondent number 7. He further seeks, he further submits that though notice was said to have been received by one Mr. D. Bora, learned government counsel on 21/5/2025 in respect of respondent number 3. However, the government counsel today submits that the said respondent is not represented by the government counsels, and accordingly he seeks issuance of fresh notice upon so and so. Prayers are allowed. Steps with in respect of the aforesaid to respondents within a period of 3 days from today.
Okay.
MS so and so submits that she has that she has not received a copy of the writ petition. Let the copy of the writ petition along with extra copy be submitted, be furnished to her within the course of the day. MS so and so, and yes, so and so seeks 3 weeks time.
Are you yet to receive
Are
instruction?
you N Kalita?
MD Bora.
Are you N Kalita? MS N Kalita and MS U Sharma seeks 3 weeks time to file return in the matter. Relist after 3 weeks to enable the petitioner so and so. To enable the state respondent file return. You first have your copy.
Hello, obliged, lord.
Supplemented item number 44.
Made with your Lordship.
Yes.
So regarding selection and appointment, my lord. Lordship, the matter is, my lord.
This matter was once.
Hard.
Yes, my
in
lord.
CAP,
Several times it is hard, CAB and it is
We have
matter.
submitted written submissions also, Your Lordship.
Written argument, everything have submitted.
Then let it be on a Tuesday or Thursday.
Lord.
Tomorrow or Thursday. Thursday.
This week I'll not be here, my
Tomorrow,
lord,
Your
I'll go out.
Lordship.
Then, my lord, post is
Take a
26.
Huh?
This week, from tomorrow I'll not be here for this week.
Then yes,
So
give a
not-
date. This not
26,
as prayed for
26.
relist on such and such date.
28, Your Lordship.
28, Thursday. That will.
Deep, Lord.
Oblige me.
Item number 45.
Yes, 45. None appears for the petitioner on call. Relist after a week on a date to be fixed by the registry.
Item 46.
Yes, Mr. Das.
This is.
Motion.
Yes.
Headmaster.
Not headmaster. This is superintendent, my lord.
Records were also asked, I think.
DPC, my lord, they have been taking time for a long time.
Hmm.
Your lordship, earlier, there was an order to provide the copy of the fate of the DPC held on 13/12/24. That they have not provided. That your lordship will get it at
Yes, because in
13.
the last order, I've said it is desirable that the returns be filed so as to enable this court to effectively hear the issue involving the writ petition. Records be also made available before this court on the next date of listing. Yes,
Lordship, we are filing an affidavit within the course of the day.
within the course of the day.
Lordship, I have
Tomorrow,
affidavits on my hand.
tomorrow,
Yes, sir, tomorrow.
Mr.
And we are, Lordship.
So and so submits that the return shall be filed during the course of the day. In view of the aforesaid, relist tomorrow, tomorrow or day after tomorrow,
Day after tomorrow.
on Wednesday, on such and such date.
Lordship,
And please mark
They will produce
presence
the
of
records also.
Mr. Birida, Senior Counsel, assisted by Suens.
And they will produce the records.
It is needless to be clarified, the records as directed in the last order shall also be made available before this court on the next date of listing.
much obliged.
Hmm.
Time being item number 6.
Pleadings completed, Lordship.
6 pleadings complete.
Complete.
What is the issue?
Penalty by the disciplinary authority.
What is the penalty?
Penalty was, he was treated, Lordship will find at page 57.
It's appearing for the other side.
Lordship,
On the last occasion also, there was no no appearance on behalf of respondent. Huh?
Standing counsel GMC will be appearing.
Where is the standing counsel GMC? This is called for the second time today. Why are they not appearing before this court? On 11th also, there was no representation on behalf of the standing counsel GMC.
Lordship, we have filed one affidavit on behalf of respondent number 1, Lordship.
Hmm.
On behalf of the deputy.
All right, where is the penalty?
page 57, Lordship.
So it is unauthorized leave absence. Without pay. Yes, what is wrong in this order?
Lordship, he was absent from initially 15/9/2018 to 6/1/2019.
15/9?
2000,
15?
15/9/2018, Lordship.
Yes.
To 6/1/2019.
Yes.
Immediately after recovery, he was ill, Lordship.
Yes.
He filed an application before the authority, Lordship,
Yes.
allowing him to join along with the duly filled up, Lordship, application for grant of leave of those days, Lordship.
Yes.
Lordship will find it is page 30 of, no, Lordship will find at page 31 that (32) is the Lordship type copy, page 32.
Yes.
Like to state, Lordship, I'll read it. With due respect, I beg to inform you that I am in medical leave with effect from 15/9/2018 to 6/1/2019, suffering from piles and etc. Now I am getting well and ready to join my duty on 7/1/2019.
Yes,
He was not allowed to join. Lordship will in the next page, Lordship will find a note at the bottom, top of the page.
yes, not to.
Not to join service. He is absent without information.
So prior to that period also absent without information. That is why you are not allowed to join.
Yes.
Now, where is the disciplinary proceedings? You have been given show cause?
Lordship.
Any procedural irregularities?
What happened, Lordship, this period from
Mr.
9.
Counsel, what is the, because you see, this is merit. Now, what I'm asking is, what is the ground of challenge? Is there any procedural irregularity, any violation of natural justice that you have?
Two things, Lordship.
Yes.
First is that, Lordship, the period from 15/9/2018 to 9 was subsequently upon examination by the medical board. Lordship, this was regularized. After being regularized even, I have filed an application. They have not allowed me to join. Because this period, the particular period for which show cause has been issued.
Admit.
Lordship, it is already admitted. Lordship. Perhaps.
No, this is listed in the admission column. Why is it listed in the admission?
Lordship. Admission column comes from the- Huh? I have been putting other-
For GMC?
Lordship.
Mr. Bora, this matter is not admitted, no?
No, their notice was issued.
Yes.
Not.
Uh,
Reading is completely.
It heard so-and-so for the petitioner, also heard Mr. S. Bora, Learned Standing Counsel GMC, MS so-and-so, Learned Government Counsel. It appears that pleadings are completed in the matter. The matter requires full-fledged hearing, admit for hearing, relist on such and such date for hearing. Give a date in the month of September.
25th. Obliged. Okay.
Handling item number 13.
None appears for the petitioner on call. Relist after 2 weeks on a date to be fixed by the registry.
Handling item number 14.
Yes, Mr. Gogoi? Can I see that order? Work charge employee. So this paragraph 4 is applicable, right?
Yes.
Gogoi?
Yes, Your Lordship.
They rendered continuous services without any break.
Some of them have granted regular scale of pay.
Yes. Some of were put up for regularization, then an order of regularization was issued. However, the same were not accepted by the government. How many petitioner in this case?
One petition.
Huh?
One.
Sorry?
No, sir.
Four.
Four petitions.
Operating parties where? I think 9.
9.
No, not 9.
13, 14. 13, 14.
Huh?
Paragraph number 13.
Miss Counsel, you are for the petitioner. You say there is a similar order and you are not even assisting the court.
I have only one order, my lord, that is.
How come you are carrying one order when you want a similar order to be passed? How can you not carry an order for yourself and for the court? Please tell me. Please enlighten me. That much you owe to the bench, Miss Counsel. Yes, Mr. Gogoi?
Paragraph number.
So I think we need not go into all this and similarly say for regularization and squarely covered by 1516. Isn't it? That should be sufficient. Heard MS? Huh? So and so learned counsel for the petitioner also heard Mr. R.R. Gogoi, learned standing counsel PHE. By way of this petition under Article 226 of the Constitution of India, the petitioners are seeking disposal of the representations dated 17/7/16, 7/7/21 and 28/6/2023 submitted for allowing them submitted for regularizing their services as done to similarly situated persons. Stop. It is submitted at the bar that it is submitted at the bar that the writ petitioners, having rendered continuous services and have put in several years in service work charged employees, and they have been given the regular scale of pay, their services should be deemed to have been regularized and consequently they are entitled to pension. Don't say it is submitted at the bar, say MS so and so. It is submitted in the bar that the issue involved in the writ petition is squarely covered by paragraph 15 and 16 of the judgment and order dated 26/2024 rendered by the coordinate bench of this court in WPC 6582/2023 within bracket lead case, wherein paragraph 15 and 16 reads as hereunder. Reading of the aforesaid vis-a-vis the endorsement made by the learned counsels at bar, this writ petition is disposed of in terms of paragraph 16 of the aforesaid judgment. Writ petition stands disposed of.
Pending item number 17.
Yes.
Lordship, here in this matter, on the last occasion, Directorate of Ayush has been impleaded, Lordship.
Hmm?
Lordship, I have received some.
Let me have a look at the order dated 11/6.
Who was impleaded?
Director of Ayush.
Director of Ayush.
Ayush Chandra.
Ayush.
Ayush. Yes.
Lordship, now I have received some instruction. It says that,
You are appearing
yes, Lordship, I am appearing.
for the newly impleaded
Yes,
respondent.
Lordship. So I need some time to place this in.
He is appearing for the newly impleaded respondent.
But according to them, my lord, proper instructions will have to be come from respond number 3.
Yes, who is
Joint-
R3?
This is BTC, Lordship.
Where is BTC?
I have informed, Lordship.
Because in fact, the last order says newly impleaded and other respondents may complete pleadings.
Yes, sir.
So what about them? Are they interested? Otherwise, you'll foreclose BTC.
They have to file their.
Yes, I think BTC who's appearing? Mr. Bora? Who appears for BTC or Rabha?
Data.
Yes, no.
We don't know, Lordship, whether she is.
There are 4-5
having-
councils.
No, I think there are a few more.
Yes, Lordship.
I think one Rabha is also there.
P Nayak is also there, Lordship.
So just ask someone to be here because then I can effectively pass the order.
Earlier, Mr. B. Sodri appeared, my lord.
Just get hold of someone from BTC. Otherwise, the problem is the moment I say none appears, later on councils come and try and get their names recorded. So if they want, I can find out how much time they want. Isn't it? Or otherwise write it like this. Heard Mr. So and so, learned counsel appearing for the petitioner. Also heard I. Bhattakur, na? No, D. Upamanyu. Learned counsel appearing for
The health department.
the health department. Mr. Upamanyu seeks for the how much time?
2 weeks, Lordship.
2 weeks time to file return in the matter. Prayer is allowed. It appears that though on the last listing, I 11/6/2025, the other respondents as well were allowed, were directed to complete their pleadings by today. However, there is no representation on behalf of the respondent BTC on call. It is needless to be clarified that if respondent BTC is if so advised, shall complete their pleadings by the next date of listing.
My lord, accountant generally is also a party.
Their respondent number?
4.
So who's appearing for 4?
Is appearing. Lordship.
So
They are
that is
planning-
respondent number BTC, respondent BTC as well as respondent number 4. Both, huh? And none appears for both. Yes, next.
Highly obliged.
Okay.
6.
Yes, why this matter is listed for orders? Yes, Ms. Moshari.
The engaged counsel R. Sharma elects on another court.
So is that the reason why this matter is listed for orders today? Is that the reason the matter is listed for orders, Mr. Counsel?
Yes. This
Mr. Counsel, when a court asks a question, try and understand what the question is being asked. Just don't come and start submitting what you are preparing in your mind. Please be alert to the proceedings of the court. You are standing before a constitutional court, Mr. Counsel. Yes, Ms. Moshari, you are saying something?
Lordship, here we were asked to file a affidavit, your Lordship. We have not received our instructions yet.
How much time do you need?
3 weeks, your Lordship.
3 weeks time. As prayed for by MSD Moshari, Learned Standing Council, Secondary Education Department, relist after 3 weeks to enable the state respondent file return positively in the matter by the next date of listing.
27.
Yes, Mr. Saikyat, contempt.
My mistakes that could not be taken.
Huh? Steps, yes.
Will be taken today, my lord.
Okay. Mr. So-and-so, Learned Senior Counsel, R. Saikia, Learned Senior Counsel, assisted by JP Barua, Learned Counsel for the petitioner submits that his office shall take steps in respect of respondent numbers 5, 6, 7.
Yes, madam.
5, 6, 7 positively within the course of the day.
Yes.
In view of the aforesaid assurance made by the Learned Senior Counsel, relist after 2 weeks on a date to be fixed by the registry.
My lord.
You want to say something?
I'm for, my lord, respondent 4.
In the meantime, so and so, Learned Counsel appearing for the respondent number 4 shall file its return in the matter,
Obliged.
28.
if so advised. Yes. 28. This is a review.
Review.
Some
But judgment was not given that time. No order was passed. It remained.
huh?
No order was passed on last petition after hearing. Matter is very simple, your lordship.
No, matter was. Sorry, I didn't get you.
It was heard by Justice Jamil.
But this is a review.
Review. And lordship will maybe please.
Yes, you are appearing for the other
Yes.
side.
Look, Friday, page 20, the order,
Page
page 20.
20.
The judgment and order dated 19/2/2018. At page 22.
So there is a administrative, this has been now listed. Where is the orders? No. Yes, please, page 20.
Page 21, paragraph 6 and page 22, paragraph 7.
Yes.
However, paragraph 6 also. However, the impugn letter dated 2/1/2018, the respondent has taken another ground that the case of the petitioner could not be considered as he was already engaged in Singapore between 4/1/2008 and 4/1/2011. This is a new ground which has been taken by the respondent after the judicial pronouncement has already been made by this court in WPC 3091 of 2016. This is not permissible. In any view of the matter, the engagement of the petitioner in Singapore between 4/1/2008 and 4/1/2011 is inconsequential inasmuch as the application of the petitioner was made on 19/12/2011. Therefore,
Anyway, Mr. Ahmed,
Yes.
you are now seeking review of this order.
This order is operative portion, you
The-
also will see at page 22, the next paragraph.
Yes. Yes.
The respondents are directed to consider the case of the petitioner for dependent employment, compassionate employment against the next immediate vacancy that arises in future. Because if
Yes.
this is,
Now, what is the review that you want?
Lordship, this is a case not of a regular filling up a regular vacancy. It relates to compassionate appointment. So on the death of a person only. that
Yes,
can
but
be-
Mr. Counsel, now you see, you are before a review court, correct? So the grounds of review are limited.
the
It
only-
cannot be a rehearing.
No, there is no hearing. I'm not asking for a hearing.
Correct. So now what is the error which is apparent on the face of the record? Please point out the error. What is the error?
Only this part, your lordship.
Because you see, if you are aggrieved by only this part, that you may agitate before the appellate court. But if you are going to agitate this before the review court, then you must show that there is an error apparent. And what is that error? Because error can't be a rehearing. Correct.
Error is that it cannot be executed, this particular order. For this particular, against the immediate.
No, but can that be a ground for review that you are having difficulty in executing the order?
Your lordship, now we cannot, because there is no question of appointment of any person against the next vacancy.
So this
That
should
we
have
can
been
then
because at the time, what was the difficulty in going for appeal?
Your lordship, we didn't have to go to appeal. We were happy with this order.
Correct, but you
But
are
what
you are
is-
saying that the operating part cannot be.
Yes, no.
Now, now please tell me how in review
The
this will
other
be
party-
corrected.
The other party came here
Hmm?
on contempt of,
Hmm?
under contempt law.
No, review grounds.
Yes.
What are the review grounds?
Because if this only reason is that this order cannot be executed.
Is that a permissible review ground? Please enlighten the court.
It can be because if this.
Can it
remains-
be a ground for review?
Lord, if this remains, what will happen?
APC. Yes,
The
yes, tell me.
in the matter of power of review,
Yes.
the High Court is the court of record.
Are you referring to any authority?
Yes, I will.
Give
take
it.
that. 2000 volume 1 SEC page 666. Is it serial number 6 of the?
Yes, I've got it. Para 14. Yes, please read.
The High Court is a court of record as envisaged in Article 215 of the Constitution, must have inherent powers to correct the records. A court of record envelopes all such powers whose acts and proceedings are to be enrolled in a perpetual memorial and testimony. A court of record is undoubtedly a superior court which is itself competent to determine the scope of its jurisdiction. The High Court as a court of record has a duty to itself to keep all its records correctly and in accordance with
So
law.
that is what, this is nothing different that has been said. That is why I'm asking, which is the error? You see, to correct the records, to exercise this inherent power, ultimately the concept of review cannot be forgotten. Review is limited by its own, because it is a creation of statute, correct? Now, even for 226 court, there has to be an error which is apparent on the face of the record. Now, you are saying that you cannot enforce this order. There is a difficulty. Is that an acceptable ground for review? This is what I'm asking you. You have to show me.
Because if this is allowed to remain, it will continue.
You're not, please show me from CPC. What are the grounds in CPC? Please show me. Yes.
Yeah.
This court is asking you.
My submission is if this is allowed to remain, it will.
Mr. Counsel, Mr. Senior Counsel, you are not following the query of the court. I have understood what you have been submitting. Repeating the same shall not change it. I'm only asking a very simple question. Powers of review. Is relist tomorrow, day after tomorrow?
Thursday.
On Thursday, as straight for enabling the learned senior counsel appearing for the writ petitioner to apprise the court as regards whether order which has been if the same is not possible to be enforced, can be reviewed by the High Court under Article 226 of the Constitution of India. Mr. Counsel, Have I heard anything today? I'm merely, so you are open to give your arguments. First, let us see. Yes. এখন ঘুরাই দিব। তেওঁলোকে নহয় জানো এইটো? Yes.
They're challenging the appointment of Jal Mitra, Lordship. Jal Mitra. First and foremost thing is that the Jal Mitra appointments are not made by the state, Your Lordship. They are made by the user committee.
Jal?
Mitra.
Any order passed by this court?
There's an order, there's similar order, but I have another order, but Justice Suman Sham on this. May I place this order, Your Lordship?
Why do you all refer to names, counsel?
Sorry, I'm extremely sorry.
I have a feeling even this court has authored,
It is judgment which I don't have exactly right now with me, Your Lordship.
yes, contractual appointment. What is the role of the state? These appointments, how can be assailed in 226? Coordinate bench judgments are there against you.
Your Lordship, the department may file affidavit.
File affidavit for what? If the department files an affidavit, the status of the employment will change. Jal Mitra board will get a semblance of state.
My father donated the land, Your Lordship.
Difficult.
Donations are only made voluntary, Lordship.
Maybe when I
Your affidavit is there, Mr. Gogol?
No, we haven't filed affidavit because
There are a lot of affidavits otherwise.
they are filed affidavit and I received the affidavit. like-
R4, R5, who is R4, R5?
R5 is the private colony, Your Lordship.
And what about 4?
What is the user committee?
User committee.
User committee, Your Lordship.
Earlier user.
What
committee
is their
that-
stand?
User committee has not filed any, and the new user committee is implemented, Your Lordship, and the advocate is. Your Lordship.
Which is that affidavit in opposition? So you want regularization of this engagement? Is
Yes.
that the prayer? Direct the respondent number 1 to engage the petitioner as grade 4 employee permanently either at so and so or under so and so.
Your Lordship.
Or compensation. Now, where is the initial engagement of the petitioner? Which page?
Initial appointment is on 2015, Your Lordship. That was.
This is done by?
It is page 18. Page 18 of my petition, the writ petition. 2 persons are engaged. One is the private respondent number 5, another is the petitioner.
By user committee.
User committee, 18 page.
What is the user committee? How is the user committee a state?
No, well,
Then
user committee,
what is your right? You are before a writ court,
Your Lordship.
right?
Yes, Your Lordship.
So this is why I'm asking you, what is your, how is this writ petition maintainable? This is by a user committee. User committee is not under the state. How can the 226 be court go into all this direct regularization?
It is not for regularization, Your Lordship. It is for either appointing.
Correct, whatever be it, it's a purely by a private body, not by a state or its instrumentality. How 226 is applicable?
After recommendation of the user committee, department appointed.
In the appointment letter, some of the writ petition appointment letters were annexed. Here it's not.
Here I don't find that
There's
letter.
there's a sign of the executive in charge. He's a special invitee in there, Your Lordship.
I remember these facts.
Yes.
There is an order of this
Yes,
court.
Your Lordship.
You don't have that.
I don't have this order. I'm so sorry, Your Lordship.
If you had given my order, I would have dismissed
Let
it
it come
right
tomorrow.
away.
I'll bring that order. Let it taken up tomorrow. I'll get that order, Your Lordship.
Try and at 2 o'clock.
2 o'clock, Your Lordship.
At 2. And give the copy of this order to.
Very well.
Number 30.
30, Your Lordship, it's a contempt.
Mr. Gogoi, there is another matter which I had fixed at 2. After that, I will take up this matter. You get hold of that judgment. And Miss Counsel, you be there at 2 o'clock. Yes.
Lordship, this is a case, Your Lordship, where 1 year back, Your Lordship, on 21/6/2024, Your Lordship. That's at page 10, Your Lordship will get the order copy of the.
Why
order.
is this for orders, Mr. Bhattacharya?
Lordship, this is your contempt matter, Your Lordship.
Yes, affidavits, Mr. Kaushik.
Madam, the affidavit has been sent for vetting. Your Lordship may take up on Monday next, Madam.
Sent for vetting, but why the affidavit is not filed till now? Notices was issued sometime in 24.
Madam, yeah.
Why is for contempt matters so much time? Superannuation issue.
Yes, Your Lord. I have insert principal. Your
Anyway,
Lordship.
when are you filing it? Last opportunity, otherwise personal appearance.
Madam, will take up on Monday next.
Monday next.
Lordship.
Mr. B. Kaushik, Learned Counsel for the respondent, assures that the requisite return on behalf of the contemners shall be on behalf of the sole contemner shall be positively filed by Monday next. In view of the aforesaid assurance, relist on Tuesday or Wednesday?
Lordship.
Monday? Released on Monday, so and so. It is needless to be clarified that in the event the return as prayed for is not filed on the next date of listing by the sole contemner, necessary orders, including personal afference, if so required, shall be issued. Sir?
31, Your Lordship.
Monday is a holiday.
Then Tuesday, Your Lordship.
Tuesday.
Next, Your Lordship, Your Lordship.
31 also same. Same. Mr. Kaushik?
Yes, sir.
Same assurance?
Same issue.
Okay. 30-31.
Yes.
32 also contempt.
Respondents have filed a affidavit.
Affidavits filed.
Lordship, I want to file a reply.
All right.
Same.
As prayed for by Mr. So-and-so, Learned Counsel appearing for the writ petitioner, relist after 2 weeks to enable the petitioner, file rejoinder to the affidavit in opposition, file on behalf of the sole contemner,
1 to 3.
file on behalf of the contemners.
All right.
Lordship, the office note reflects that the service is complete on all.
Service complete, Mr. There, huh?
3, 5, and 6, and for the respondent. And we have already filed affidavit.
You have filed.
Yes, sir.
All right. Heard Mr. SS there, right? S there. Learned Counsel appearing for the petitioner, also heard MS. S. Khatonier, Learned Counsel appearing for respondent number 3, 5, and 6. Office note dated 1/8/2025 indicates that service in respect of the other respondent numbers 4, 7, and 8 stands has been completed. Accordingly, service in respect of the remaining respondents also stands complete. MS so-and-so submits that an affidavit in opposition has been filed. You want to file a reply?
I'm not opposing our stance.
Which is on record, huh? What about respondent number 1? Who is 1?
The higher education. department.
Where are they? None appears for the respondent. Yes. But where are they? What about their return? None appears for the higher education department on call. It is needless to be clarified. Returns, if so advised, shall be filed by all remaining respondents by the next date of listing. 2 weeks.
Number 34.
Steps.
In this case, H. Gupta is appearing, Lordship, as per in the instruction, 1 week time may be granted to take instruction. Lordship.
Instructions for what? I
No,
think some
no,
steps,
Lordship.
no
For
steps have
sorry,
been
Lordship.
received.
It is for step.
Yes.
1 week time may be granted to take step.
Take steps or instructions
No,
to
no,
take
sir.
steps.
No.
As prayed for by MS.
Adevi.
So and so on behalf of Mr. H. Gupta, Learned Central, Learned CGC, relist after 2 weeks to enable the petitioners take fresh steps in respect of the respondents as directed earlier. All right. Dilu to 2 weeks.
35.
Yes.
I'm praying for 2 weeks.
Because there is a hearing scheduled today, Miller, with regard to the steps for compliance.
All right, Barthakur. As heard Mr. S. Barthakur, Learned Counsel appearing for the petitioner, as well as Mr. B. Kaushik, Learned Counsel appearing for the sole respondent stroke contemptor. Mr. Kaushik so and so seeks 2 weeks time to file affidavit in opposition in the matter. Prayer is allowed, released after so and so to enable the contemptor file so and so.
36.
Here, Your Lordship, this matter relates to payment of pension.
Arrear salary,
Payments of pensionary.
pensionary and arrear salary also.
Arrear salary also.
Yes.
I need some time, Malala. I have not.
What time? Contempt matter?
Two, Malala.
Huh?
Some time I will get it. One time.
Already order of this court is there, and this matter is also pending since from the beginning of the year.
Lord.
I
And
need some
initial
time.
order is.
Last chance.
Malala.
Mr. S. Barthakur, Learned so and so, and also Mr.
PK Bora, Malala.
PK Bara for respondent number.
One, Malala.
Respondent number 1. Respondent stroke contempt number 1. H. Halia, respondent contemptor number 3. 2 Deori. B. Deori, respondent contempt number 2, right? Correct? Only 3. So you all are filing?
No, Lordship, here because say he's an employee of the education department and it has to be finalized by the education authorities first. So let
No, but did you have any role to play or not?
not yet, Lordship, because it has not been finalized. No.
I understand that unless that is done, your role doesn't come. But why don't you put that in the affidavit? Or okay, fine. Mr. So and so, Learned Learned Counsel appearing for respondent number 1 seeks 2 weeks time to file return in the matter. Prayer is allowed. However, it is clarified that in the event the affidavit as prayed for is not filed by the next date of listing, necessary orders, if required, to secure, if required, including personal appearance of the said contemptor, shall be issued.
Obliged.
37.
My lord, 37 and 38, my lord. Out of the same order, my lord.
Yes.
And a notice issued in the month of April, my lord.
Lordship, some more time.
All right. As prayed for by MS.
P. Thapa, Lordship.
P. Thapa, Learned Counsel appearing for respondent stroke contemptor numbers. Sole contemptor or
Sole, my lord.
sole?
Yes.
Sole contemptor. Huh? Relist after 3 weeks to enable the contemptors file affidavit in the matter.
My lord, these two matters may be listed along with my lord contempt issue 210, my lord. 210.
List along with, please give that number.
210 of 20. Obliged.
Just give it in writing so that there is no.
Obliged.
Yes.
39.
Here your lordship will find your lordship in the record, your lordship. They have, the contemptor has written a letter directly to this honorable court, your lordship.
Is it?
To the assistant registrar.
So I don't know why this,
Lordship, this
they
is-
don't just
this
don't.
is the way-
Perhaps, no, this, I think it is actually inadvertently done because of the show cause notice received. Yes, yes. So you,
An accommodation on behalf of Mr. S. Das, he's on bereavement today.
Mr.
S. Das.
He, as does is appearing for the,
Respondent number 2, your lordship.
what about 1?
One has your lordship, no one has appeared, your lordship, that letter.
But
is-
who is 1? Because then,
He is the secretary, your lordship. Ultimately.
can Mr. Das appear for 1 as well?
And he can.
He can. So then I will say that let Mr. Das obtain instruction.
My lord, I'll also inform.
Yes. Heard Mr. B. S. Barthakur, Learned Counsel appearing for the petitioner. Mr. Barthakur submits that it is it appears that though no learned counsel has entered appearance on behalf of respondent number 2, however, the Secretary to the Government of Assam Higher Education Department, within bracket, respondent number 2, has directly communicated to the Office of the Deputy Registrar, Guwahati High Court, Guwahati, by a letter dated 9/6/2025. Stop. It appears that this court depreciates such direct communication from the contemners to the registry of this court. The contemner should have been represented by a learned counsel. Stop. Be it as it may, Mr. B. Kaushik, learned counsel, appearing on behalf of Mr. S. Das, who is appearing on behalf of the contemner number 1, submits that. No, you are otherwise for?
No one is appearing for contemptor one.
That letter has come from whom?
Contemptor one.
From your.
Contemptor one.
Oh.
Second, not mine.
You are confusing me now.
Sorry.
So he tekhete je koisle, you say that direct query by respondent number 1. Don't say 2, huh? 1. However, today when the matter is called, Mr. B. Kaushik submits that Mr. S. Das is entering appearance for respondent number
2. He has already entered appearance. Your Lordship has asked me to inform him that whether he can appear for respondent number 1.
No, now who has given this letter?
Respondent number 1.
That your Lordship has-
ঠিক আছে 1A মই ফাৰ্ষ্টত কোৱাতে ৰাখা তাৰ subsequently কোৱা যে though has appeared entered appearance on behalf of 2, however submits that he may obtain instruction as whether he shall also enter appearance on behalf of 1. In view of the above, relist after 2 weeks on a date to be fixed by the registry. Take high diba man ঠিক কৰি দিম
40. That's your last. And as per office note dated 23/6/25, service upon respondent number 5 is complete.
5 complete. What about the other respondents?
Yes, the respondents they've already.
1 to 4. So all complete. Heard Mr. J. Patwari, learned counsel appearing for the petitioner. Also heard Mr. C. Sharma, learned counsel appearing for 1, 2, and 3. And Mr. So-and-so for 4. 4, right? Office note dated so-and-so indicate that service in respect of respondent number 5 stands complete. Relist after 3 weeks to enable the respondents file return in the matter.
And may I have your lordship indulgence to make one small prayer? The petitioner before your lordship is a class 2 student represented by a legal guardian. Her father was killed by her own mother and the mother is lodged in jail and she is the only eyewitness. That's why, my lord, because of the financial constraint, we have prayed for releasing of provisional pension in the petition. And lordship kindly peruse order dated 10/4/25.
All right, then next week.
No, lordship has already directed to release a provisional pension, but the authorities are not complying. Last paragraph of the order dated 10/4.
Yes, 10-4. Why this has not been done?
Lordship,
Huh?
Lordship, I'll take
It is Mr. Patwari, Mr. So-and-so further draws the attention of the court to the order of this court, to the last order of this court, I 10/4/2025, whereby considering the matters in its entirety, in the interim it was provided that the respondent shall release the provisional family pension to the petitioner. However, the same has not been done till date. Mr. Sharma shall obtain instruction in this regard by the next date of listing, failing which the concerned respondent shall be personally present in the court on the next date of listing. Relist date of next week on such and such date, Friday.
Item number 41.
May I please, your lordship? My lord,
Yes.
my lord, IA is filed for correction of the honorable court order, my lord. I have
For
an,
this court?
yes, my lord.
Yes.
Para 5, page 6, my lord. I have stated, my lord. Petitioner's work order is wrongly recorded, my lord.
Para?
Para 5, page number 6, my lord.
No, in the order where, which part?
Yes, my lord. My lord, page number 11, my lord. 11, operating para page number 12, my
second,
lord.
one second. So the work, just the work order needs to be, huh? The right order is this in SAKAO Rangla Sashwa Bharat Mission 5816 so and so, dated 21/3/17. Huh? This is the and in which paragraph? Page?
Para 5.
That I have seen in the order.
Order, my lord. Para 12, my lord. Pursuant to the from the past.
Para 12.
No,
Page 12.
page 12.
Yes. Which
Pursuant
part?
to the aforesaid white SAK Rangia Swachh Bharat Mission oblique 57
Where are you reading from?
from the
From the top. Yes.
pursuant to the aforesaid SAKAO.
So this part needs to be changed.
Yes, my lord.
This is part of. Okay. Anyone appearing for the other side? I think this can be corrected. All right. Heard Mr. So and so.
Ego.
High Learned Counsel for the petitioner. Also heard MS. U Sharma, Learned Counsel, appearing for respondent number 3. By way of this application, the applicant is seeking correction of this court's order dated 19/6/2024, passed in WPC 2053/2022. Mr. A. Gohai, Leonard so and so submits that due to an inadvertent communication error, the reference of the petitioner's work order in the judgment and order dated 19/6/2024 was wrongly recorded, for which the present application has been filed. Paragraph 5 or paragraph 5, only 5 I think reference.
Yes,
Para 5, 6, 7 of the application reads as under. And that report did you MS so and so does not oppose to the prayer made. Prayer so and so. Reading of the aforesaid, it appears that in the order of this court dated 19/6/2024, inadvertently it has been the petitioner's work order has been inadvertently recorded as number SAKAAO/Rangya/Swabharat Mission /57/2017 18/777 dated 21/3/17 in place of number SAKAO, it on page 6 paragraph 5 dated so and so. That being so, the order dated so and so stands corrected. The order shall now read as so and so in place of so and so. This order shall be also be a part of the order dated so and so disposed of.
42.
Yes, Mr. Day.
Here too, Lordship, the service is complete and then affidavit has been filed, but the higher education department has not
So
filed any.
3 and 4 it has been complete. 4 is also complete. Now what about 1, 2?
1, 2 is the department, Lordship.
1, 2 is
One is the department and I'm for a 3 and 5.
You are for 3 and 5. Okay. Heard Mr. S. Dale, Learned Counsel appearing for the petitioner. Also heard Mr. B. Kaushik, Learned Counsel appearing for
On behalf of ELDA.
L.
S Das.
S. Das for respondent number
1 and 2.
1 and 2. And MS
S Khatonia.
S. Khatonia for respondent number
3 and 5.
3 and 5. Office note dated so and so, dated 5/8/25 indicates that service in respect of respondent number 4 stands complete. What about 2? So, in view of the above, relist after 3 weeks to enable the respondents file necessary return in the matter.
There's an interim one.
Interim, if any, shall continue till the next date of listing.
How much of like?
Board is over.
দাদা এই ঘূৰাই দিছে নে? বেলেগ ধৰণৰ কপাল এটা আছে, খবৰ নাই। নহয় নহয়, আগৰ কোনো ছুপাৰ ফাষ্ট অকমান ডাইৰেক্ট ৰাখিছো আমি বেলেগ একো নাই ডাইৰেক্ট ৰাখিছো নহয় নহয় সেইটো কাৰণে ৰাখিছো হেল্ল' আকান্ত ফল অফিচাৰ আছে নে আপোনাক টাইপিং কৰিব
But petitioner is not expired in this case.
Hmm?
Petitioner is not expired in this case.
Expired?
No.
Expired.
Perhaps it was found in the video also, Lordship. That
Not petitioner, 90 days period.
Otherwise, Lordship, I have gone. I'm shocked after hearing this.
Even I am also shocked. Equally shocked as you were. Expiry of 90 days, Mr. Counsel.
Yes, Lordship, but that is on that expiry should be, Lordship, on because this first extension was been.
I think expiry should be on 29/3/2024.
Yes, yes.
Yes or no?
Yes.
Yes,
But first extension was been done on 27 June, Lordship.
Yes,
After the expiry.
After the expiry, yes, Lordship.
So that is the whole issue. Deepak Mali's case.
Deepak Mali, there is one thing with Deepak Mali, Lordship.
Hmm.
Deepak Mali basically ruled 10, 6 and 7.
What about the coordinate bench judgment, which is?
But coordinate bench judgment, Lordship, here. Yes, Diganta Kolde here, Lordship, Ajay Kumar Chaudhary was been elect, Lordship.
Yes, read paragraph 29. Read paragraph 29.
The law as laid down by the Honorable Supreme Court therefore amended that a suspension order being issued the currency of the would not extend 3 months if within this period, the memorandum of the service is not served on the delinquent officer employee, the second part of the law mandates that if the memorandum of charges are served is a reasonable order must be passed for the extension of the suspension. The second part of the law declared by the Honorable Supreme Court cannot be read in isolation and has to be read in conjunction with the first part. Accordingly, it is to be understood that a currency of an order of suspension while not being permissible to be extended beyond 3 months from the date of its issue, if a memorandum of charge sheet is not served on the delinquent officer and employee, and if a memorandum of charge sheet is so issued in a period of 3 months, the same must be necessarily be accompanied with a reason order extending the order of suspension. In other words, either on the date a memorandum of charge sheet is so issued or invariably on the date the same is served on delinquent concern, such memorandum of charges must be necessarily be accompanied with a reason for extending the suspension of the delinquent. The effect of
read.
The effect of non-service of such a reason order on the delinquent when the memorandum of charge is so served would be that the order of suspension would cease to operate and the delinquent officer employee would be required
To be reinstated in his service. Now come, 30, read 30, finish it. Applying the conclusion.
Applying the conclusion reached hearing about the facts and circumstances of the present case, it is an admitted position that neither on the date of issuance of the so-called notice dated to the petitioner hearing nor the date it was so served upon him, the respondent authorities have not on a review carried out of the suspension order of the petitioner issued a reason order for the extension of the period of his suspension and served the same on him. Accordingly, applying the law declared by the Honorable Supreme Court in case of Ajay Kumar Chaudhary 21, this court has no hesitation to hold the suspension of the petitioner cease to have an effect and same cannot said to be in concurrency after a date of so-called notice dated 24/6/2023 was served upon the petitioner. The subsequent extension is effected with
This is that point. Read.
The subsequent extension is effected with regard to the period of suspension of the petitioner in view of the above noted lacuna would be of no consequence.
So you see, I don't have, you see, this is a coordinate bench judgment and I am with respectful agreement of the same thing, and Deepak Mali is also there. So if you have any grievance, you. There was a rule.
So application of that in regard to Assam government lordship.
Your own notification for that OM.
OM of 2000.
Yes.
Within a period of 3 months, then you can keep it for service for 6 months.
Yes.
Yes, also we have.
Yes, your own OM.
Yes, also I'm not.
Then.
That is difficult.
Yes.
Subsequent to this.
See, I appreciate the arguments, but councils, when you are, when there are already coordinate benches judgments also, so then this it becomes difficult.
Yes, Lordship.
Yes.
Subsequent to that, the judgment, there is another judgment passed by the coordinate bench of the Honorable Court. In that, this judgment, case of Lordship Deepak Mali, as well as the 20.
Which one? This Sudhir Kumar Paul. Yes, what has happened here?
Yes, Lordship, the court's finding is start from page para 7, Lordship.
But before I go to the Sudhir Paul, one thing you must remember, I think in this decision, perhaps because going by Ajay Chaudhary case, where at that time that extension was given, the court in 226, perhaps that is the observation which you want to draw the attention of this court, right? The court did not exercise discretion.
No, that's different case.
Is a different case?
Yes, Lordship. Start from 11.
But before I go to this court, this coordinate bench, you see, as far as Deepak Mali is concerned, and as far as Digonto Kolita is concerned, the present case is squarely covered by the facts of Digonto Kolita. Here in this case also, the suspension order admittedly was of 30/12/2023.
Yes.
The first show cause notice was admittedly given within the 90 days period, that is 1/3/2024. However, no reasons for extension was there, right? Thereafter, the statutory period of was expired on 29/3/2024.
90 days.
Correct, 90 days. Until then, there was no reasoned order for extension. The extension admittedly came on 28/6/2024. That is after the expiry of the 90 days period. Now, your office memorandum 4/2/2020 also stipulates that it has to be extended within, not after the expiry.
Within 6 months, that's it.
Correct, whatever be it, that is within the period, not after the expiry period. Now, here the question is therefore after the expiry period, can you now say that no, it is still carrying on because later on we have given reasons. That is the whole issue. Now, yes, let us see this. Mr. Chaudhary, Sudhir Kumar Paul is sought to be relied. You have a copy?
No. Sudhir to আছে নেকি?
আৰু যে ইয়াত আছিলে তাত আছে নেকি মই দেখা যেন লাগিছে এই যে কিছুমান এইখিনি নেকি তোমাৰ চোন ইয়াত আছে নেকি মই দেখিছো You have a copy? Give it to Mr. Chaudhary. তাতে আছে নেকি
দীপক মানে কাজ আছে এইটো লেসেন দাদা প্যারা 7 স্টার্ট করব 5/6/2020
ऐसा at night. Okay. All right, paragraph. Mr. Gautam, Mr. Chaudhary, have you read? You got it. Okay. Para 7, no?
Start from para 7.
All right.
Para 7 onwards.
Yes.
Now, Milord will kindly come to para 13.
One second, I am just reading it. Which is this Sonowal's case?
Yes. Audit Sonowal. Before Lordship goes to
Para 13.
Para 13.
Yes, read.
Coming to the present proceeding, it is evident that the petitioner was suspended on 14/12/23 with effect from 11/12. Before expiry of 3 months, disciplinary proceedings were initiated by issuance of a show cause notice dated 1/3/24. Subsequently, the review of suspension was also undertaken on 26/24, 2/9/24, and 10/12/24, which was also within a period of 6 months from the earlier order passed. Now, Lordship need not trouble your Lordship others. Now come to para 15. Why in this case?
Hmm.
Because the disciplinary proceeding was over.
Hmm.
Para 15 at page 13 of the judgment, last sentence.
Hmm.
Accordingly, in view of the discussion above, this court is of the considered view that facts do not call for any interference with the order of suspension, order dated 14/12, or extension or review of the suspension, as respondents have followed the timeline and procedure prescribed in OM dated so and so. What is, however, noticed during the course of hearing is that disciplinary proceeding has been concluded and the matter is before disciplinary authority, but no final order has been passed.
Here also, I think.
Nothing has been done.
DP has been
Oh, why not?
DP has been completed, yes.
On what basis are you saying that? On what basis are you making that submission before the Constitutional Court? Where is that written instruction? That the DP is concluded?
Yesterday I had talked with
Where is that information, Mr. Counsel?
there is no document, but there
Then-
is information that the DP has already been completed.
So you see, if you have to give an instruction, give a concrete instruction.
Inquiry has been completed, Lordship, completed, Lordship.
My lord, I think judicial discipline demands, my lord, matters should rest at some level.
That's why I was thinking maybe it requires to be referred to a larger bench,
Should be.
Mr. Chaudhary, because every time this issue comes up,
Some judgment will be placed.
yes,
There's no, I mean.
perhaps, I mean, I was just thinking that.
Coordinate bench is bound by an earlier.
Correct,
coordinate bench.
correct. So, you see, the other judgment which you are relying is very clear.
Very clear. There
Now-
are two stages.
Yes, 2 stages.
And that two stages part has not been dealt here.
Yes.
This is a judgment per incuriam.
But
This judgment.
yes, you're right. But then in this judgment, the perception was that Deepak Mali is in reference to that CCS rules. But in the Assam, similar CCS
Similar
rules not
procedures
there.
there.
But in that office memorandum, of course, it says within the expiry of the 3 months.
3 months.
So,
So I think to decide Assam cases, we need not travel to Supreme Court. Our departmental manual itself is good enough. According to me, subject to.
show a manual consult.
কোনটো paragraph আছিলে? তহঁতে কিতাপবিলাক নানো আৰু বিচাৰি পোৱা নাই।
Manual. Just
Yes, I got it, madam.
the court, Maitri, did you auction manual কোনখন বিচাৰিছা? Service manual, I
Yes,
think.
yes.
There is a departmental something, I think,
Yes,
guidelines or
madam,
something.
I think the heading is Manual of Departmental Proceedings.
Correct. Just, Mr. Chaudhary, please ask your junior to.
I'll just find it.
No, ask your junior.
Yes. এখন দেশ, এইটো লওক। Point 2.8. Yes. Please come to 2.1.8.
Yes.
The following principles and procedure with regard to suspension need strict compliance. Suspension should be resorted to only in cases where major penalty is likely to be imposed if charges are proved. The charges and statement of allegation should be served within 3 months from the date of suspension, failing which government servants shall be reinstated. In case where it is not reasonably practicable to prepare charges for service within 3 months from the date of suspension, and the continued suspension of the government servant is considered necessary in the public interest, the authority concerned should move the personnel department through administrative department well before the expiry of the period of 3 months, with a letter detailing the nature of allegation and reasons for which charges could not be prepared, so that the personnel department could advise whether any further extension of the period of suspension should be permitted or not. Well, this is much more better method inbuilt mechanism.
Much before.
Much before. This is of Milord.
Well before, sorry.
5th of September 1979. So Milord, idea is, it is not the administrative department who will take the call, it is the personnel department. Idea is whether there is a requirement of extending and that everything has to be done within 3 months. So how can this OM stand, Milord, on the face of this? Though this is not under challenge.
See, the thing is that even Ajay Chaudhary have very clearly said, if you don't extend,
Yes.
reinstate.
Yes.
That particular paragraph, in my understanding, would be in reference to that specific, in what happened in that case.
Next para 2.
Yes,
Yeah,
yes,
para
yes.
2, 3 is clear, Milord.
Yes.
There what happened, that was a case of third extension.
Correct, correct. So in that
Yes.
eventuality.
If the
Otherwise,
facts
I think this much,
for example, the judgment which has been cited by my learned friend.
there the
a similar,
departmental proceedings were already initiated. This is what in Diganta Kolita, you have. Huh? No, there that particular paragraph 15, I think. Because para 11, it says a perusal of so and so is required to be issued before expiry of so and so. Then at para 13, it says before expiry of 3 months, the disciplinary proceedings were initiated by issuance of so and so dated so and so. Subsequently, the review of suspension was also undertaken on so and so, so and so, and so and so, which was also within a period of 6 months from the earliest one. So in that facts,
it was a judgment in the facts of that case.
yes.
Document I have received, got lodged that the departmental inquiry has been completed. It is pending before the highest authority. Department has received the inquiry report that is indicated.
Lagon was probably was a no, Lagon plus 4.
All right. All right, Mr. Counsel, please take your seats now. Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. A.K. Ajadna, Learned Counsel, appearing for the writ petition. Also heard Mr.
S. Doctor.
S. Doctor, Learned
Standing Council Revenue Department.
Standing Counsel, Revenue Department, and Mr. C.K.S. Barua, Learned Government Counsel for the State Respondent. By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned order dated 30/12/2023 passed by the District Commissioner Bongaigaon, Assam, by which the petitioner has been suspended from the post of Lot Mondal of Boitamari Revenue Circle. Stop. Inter alia bili koi dipa, huh? The brief facts. Yes, Mr. Chaudhary. The brief facts of the case is that in the year 2021, while the petitioner was posted as a lot mondal of Boitamari Revenue Circle in the district of Bongaigaon, Assam, Mr. Gautam, sorry, Mr. Ajad, which paragraph is the suspension in your pleadings? In connection with a sale transaction in respect of sale of a plot of land measuring 5 bigha covered by dag number 18, patta number 29 of village Korea under the Boitamari Revenue Circle, comma. Yes, suspension order page, or you give me the paragraph number.
Page 86.
Hmm?
Page 86, annexure 16.
Page
86, paragraph 17.
Okay. The comma, based on an FIR, the respondent number 3, i.e. the District Commissioner Bongaigaon, on 30/12/2023, placed the services of the petitioner under suspension by stating full stop, stop. Thereafter, on 1/3/2024, the respondent number 3 issued show cause notice under Rule 9 of the Assam Services Discipline and Appeal Rules 1964, read with Article 311 of the Constitution of India, against the petitioner. The petitioner, upon receipt of the aforesaid show cause notice, submitted his reply on 23/2024. It is the specific case of the petitioner that, in terms of the law laid down by the apex court in the case of Ajay Kumar so-and-so, reported in 2015 7 SSC 291, read with the office memorandum dated 4/2/2000, comma, the don't say the office memorandum, so and so, the suspension order cannot extend beyond 90 days unless and until the same has been extended, same has been reviewed and extended by stating reasons thereof. Since the impugned suspension order, since the 90 days time in the instant case is expired on 29/3/2024, by which date there has been no extension of the suspension period by giving reasons, the instant writ petition has been filed. Stop. Mr. K.N. Chaudhary so and so submits that the issue involved in the instant proceeding is squarely covered by the judgment and order of the coordinate bench of this court rendered in the case of Digonta Kolita versus the state of Assam and others, reported in 2024, volume 4 GLT at page 1007. He further submits that it is apparent reading of the show cause notice dated 1/3/2024 issued to the petitioner during the currency of the 90 days period that no reasons whatsoever extending the time period of suspension has been made. He further submits that admittedly the extension of the suspension was made on 28/6/2024, i.e. after the expiry of the said 90 days. Hence, he submits that the order of suspension is illegal and warrants interference of this court by reinstating the petitioner. Stop. Per contra, Mr. First, who submissions? CKS.
He has filed affidavit. He has filed affidavit.
Mr. CKS, no?
No.
Barwal, and it's so and so submits that the decision of the coordinate bench in the case of the Ganta Kolita Supra was in reference to the decision of the apex court in Deepak Mali so and so reported in so and so, wherein the decision of the apex court was in reference to the rule
10(6).
Rule 10(6) of
7.
Rule 10.
6 and 7 of Central Civil Services, Rules 1965.
Just say it little slowly so that he can.
Rule 10(6) and 7 of Central Civil Services, Rules 1965.
Okay. He then say Mr. So and so submits that the coordinate bench of this court in the case of Sudhir Kumar Paul versus so and so in WPC 5623 of 2024 in a similar situated facts has rejected the challenge made to the suspension in the on the ground that the disciplinary proceedings therein has been concluded in the meantime. Stop. He further submits that the central rules, which were the basis for the decision rendered before the which was the basis on which was the basis which was the he further submits that since the principle laid down by the apex court in the decision of the Deepak Mali Supra was based on the central so and so rules, the same is not applicable in the facts of the instant case. Stop. This is what
review period is within 6 months.
that is which OM? That 4.
2020, yes.
4.
Yes,
He further submits that in terms of the office memorandum dated 4/2/2020.
That is indicated in Sudhir Kumar Paul.
The time frame for review is a period of 6 months. Stop. So if we go by 6 months period of 4/2/2020, then this is within 6 months. This is what you are saying. And that OM is not under challenge. Stop. I have heard the learned counsels appearing for the parties at length and have perused the materials available on record. Our submission of login. He further submits that in the instant case, apart from the departmental proceeding, where is that letter you just gave me? He further submits that as per the instruction received from the Office of the Government of Assam Revenue and Disaster Management Department by letter dated 18/12/2024, the departmental proceedings drawn up against the petitioner appears to have been concluded. Stop. He further submits that the petitioner in the meantime has also retired from service. This was your submission. Mr. Chaudhary, you came exactly in the appropriate time. Just one clarification from you, because the other argument which is coming from the other side is that the time frame under the OM of force
6 months.
is 6 months. And in the present case, admittedly, this extension was within 6 months. What do you have to say to that?
You know, that is contrary to the law laid down by Ajay Chaudhary's case. How can that even be countenanced, my lord? And on the face of the earlier notification, whether that has been superseded, no.
No, but that departmental promotion notification
Yes, that has not been
is an
superseded.
executive instruction?
Yes. That is of 89, 79.
71, right?
79, my lord.
ABP. What does ABP means?
That's the number normally is given in all this.
What is this? Is this an OM? Because if it's an OM, subsequently they can change the
provided, my lord, it is overruled or superseded.
But now, as of now, this 2000 note OM is not under challenge.
You would recollect one thing. When it comes to relaxation of age, there was an OM of Government of Assam of 1951.
In that APSC case.
Whereas, my lord, in 80s, on 27th of March 1980, Assam government came up with an OM regarding giving age relaxation. My lord, I think a coordinate bench of this honorable court has struck down the subsequent one. Same is the position here, my lord. This is not 71, it is of 79, my lord. Next page.
218? 218?
No, 284, next page, my lord. Normally it's given towards the end.
Okay, so OM 79. This is also an OM.
This is also an OM. So, my lord, they are not
because
even
generally, if there are two OM, subsequent will, I think, prevail.
No, there's nothing like that.
There is a decision, I think.
No, my lord. No. Then it has to be inferred as a case of implied repeal.
1 second, just
Yes,
1 second. I'm not sure if I can immediately find it, but I remember.
The proceeding over depend very well.
Mr. Chaudhary, then should I keep this for further hearing? Because I think with all fairness to the other side, perhaps a little bit of more argument perhaps would be necessary for this.
Lordship may keep it.
Because I was willing to otherwise dispose it off by following one of the view. But the only thing I'm now having a little difficulty is that you see now this OM has come.
Yes.
The OM has given a period. Whether that is correct, not correct, it's a different thing. But how the court is going to now, or whether the court is bound by that OM, if there are two OMs, whether the subsequent will prevail, or because I am also this court is mindful that that OM is not under challenge,
Yes.
right, by neither parties. So that OM
Correct.
stands. Only thing, as per that OM, if this court has to go, then the period is
My
6
humble
months.
submission, my lord, Lordship will settle this once for all.
So that is why I'm saying then I
Lordship,
think
keep it for
because
further hearing.
I don't find
Try to
any
assist your lordship
because
in
I
this
don't
case.
find any argument
Yes.
made in this regard
Yes.
before the other coordinate bench
Yes.
as regards this particular
Yes,
point.
yes.
So therefore we
Since
cannot say there
I
is a
have already
precedent.
retired, there is no earth-shattering hurry also.
Yes, yes.
Lordship can keep it for further
All right,
hearing.
all right.
I'll assist me, lord.
Yes. When do you want it?
First week of September.
Hardened part. Should I say hardened part or should I just?
Yes, hardened part.
Huh? Because I was almost dictating the
Yes, hardened part.
hardened part and list for further hearing on such and such date. In the meantime, you have a look at it if required through an additional thing. You, correct, because this OM seems to be there. Now this court has to take a call.
Take a call.
And the validity of I mean, this question I don't find was gone into by the coordinate bench in Sudhir Kumar Paul. Whether
I think in Sudhir Kumar Paul, there
it
is
was
one sentence
assumed
where the learned court, my lord, observed that this OM is not under challenge.
yes, and it has simply because there that is one thing and
So,
said it is assumed here that because it's 6 months, therefore it is done within 6 months. But this argument which you are now making
was not addressed.
There. So unless an argument comes, where is the occasion for the court to deal that issue?
Correct.
So now that you are making an argument before this court, I have to address the issue,
Yes.
isn't it?
I'll do that.
So
I'll file an additional.
to my understanding, there is no precedent as far as that issue is concerned. Perhaps some
gray areas are there.
Perhaps. Therefore, you have a look at it.
Lordship will keep it in the first week of September. In the meantime, I'll also file an additional affidavit.
Yes, list on substantiated corridor. I am just keeping these decisions. Sudhir Paul and the Deepak Kalita.
Digonto Kalita.
Digonto. Deepak. Egita Belake talk, huh? And in the meantime, you find out what happens to the up-to-date status of the that instruction. I'm not recorded anything.
My lord, honestly speaking, I was also not aware of the fact that he has retired in the meantime.
You also check?
Yes.
You also check?
Yes.
Because I have not recorded anything.
No, it's all right.
So you can also check because he says he's retired also.
How fine. Deep your time.
Pending item number 29.
Yes, Mr. Gogoi, did you find that order?
Yes.
In this case, the engagement letter is not there.
List is there where engagement has been made, page 28.
আপনার লাগাতে আমি দিয়েছিলাম
Okay, respondent number 5 has filed an affidavit in opposition. So there is
Yes.
an engagement letter is there mostly.
Where?
Yes, yes. Page 56 of the affidavit of opposition filed by respondent number 5.
The respondent number?
The affidavit in opposition filed by respondent number 5.
Page?
Page 56.
I think R4, right? The affidavit is R4.
Okay. 1 minute.
Yes, R4. 50,
Five, five.
huh? By Raziul Haq. Google,
Page 56, your lordship.
page 56.
56, affidavit in opposition filed by respondent number 5. By respondent number 5 is.
You are right, you are right. I'm sorry. You are right.
That's the engagement letter.
1 second. Yes, in this affidavit, you want me to go to which page?
Page 56, it's the engagement letter. The by respondent.
Page 56.
56, lordship.
That is the averment, but is the engagement letter there?
Yes, your lordship.
Page
56, annexure E.
56,
Affidavit of opposition
57,
filed by-
58. No, here I think it got changed.
Yeah, another affidavit by the.
No, I'll find it. I think 56 you said, no? 45. Is it annexure D?
Sure. It's annexure.
Possibly.
Hey, if I have
That's number 4.
over the.
That's number 4 to believe. That's number 4 to only page 51. Lot.
1 second. My brief
Turning
is.
page. This different, your lordship. 78 minus 56.
That is the engagement.
Engagement letter. 78.
No photos থাকে না?
Yes, Mr. Gogol.
That's the engagement letter, so kindly see the down.
Yes.
Yes.
General Secretary, User Committee, Special Invitee, WC, what are you? Same.
Same.
This is same to the other case. And here how many? There are 2 or 1?
1.
The department is involved with the water reader committee. It is the approval of the authority, your lordship. So the payment is made by the public accessor, your lordship.
Okay.
So how that this writ petition cannot be entered in your lordship? The private respondent is salaried by the public accessor, your lordship. So he is a special invitee, but he is involved in the water reserve committee. Department is involved with the water reserve committee. This is not the authority.
All right. Dig down. Part MS.
A Begum.
A Begum. A Begum, Learned Counsel appearing for the petitioner. Stop. Also heard Mr. R.R. Gogoi, Learned Standing Counsel for the PH department. Stop. By way of this petition under Article 226 of the Constitution of India, comma, the petitioner is seeking a writ in the nature of mandamus to direct the respondent number 1, the state of Assam, represented by the Secretary to the Government of Assam, Public Health Engineering Department, Dispur, Guwahati 6, to engage the petitioner as grade 4 employee permanently either at Doityalbori Pipe Water Supply Scheme, Morigao District Part, under Dhing PH Division, Nagaon, or in any other pipe water supply scheme under said Dhing, within bracket, PH Division, Nagaon, Assam. Stop. Inter alia bili koi di pade. The brief facts of the case is that the brief facts of the case, as stated in the writ petition, is that on being approached by the respondent authority, the father of the petitioner, i.e. Abdul Samad, the owner and possessor of the A schedule land, donated a portion, i.e. 1 bigha schedule B land, of said land to the respondent authority, and the said authority constructed office house and run the office of Doityalbori Pipe Water Supply Scheme, Morigao District Part, under Dhing PH Division, Nagaon. It is the specific case of the writ petitioner that, as per the oral agreement, the respondent authority ought to have engaged either the father of the petitioner or any of his family member to any grade 4 post in the said scheme under the department. It is the specific case of the writ petitioner that, since the department did not appoint or engage any of them in the said scheme, and subsequently the Schedule B land was mutated in the name of the department, the petitioner being the only interested eligible son of his father, represented before the authorities, however, the same resulted. However, the same was not considered. It is the further specific case of the writ petitioner that in the year 2015, the Users Committee under the department engaged the petitioner and directed him to work as volunteer in the said scheme, and accordingly, the petitioner has been working as such in the said scheme since 15/12/2015. However, till date, he has not been given any remuneration for such work. It is the specific grievance of the writ petitioner that the Users Committee illegally deprived the petitioner don't say illegally did not absorb the petitioner in a permanent post. Stop. Miss Counsel, your writ petition is very, I must say, it's like you're seeking two reliefs together. At one point, you're saying because of that length thing, compensation that happened long back. Thereafter, in the meantime, you got this 15. In 15, you got engaged as a volunteer. Now you are clubbing both the issues. How can this writ petition stand like this? Anyway, MS so and so, learned counsel for the petitioner submits that since the user committee had engaged the petitioner's service, the petitioner is entitled to be permanently absorbed. This is what you're saying, isn't it? Permanently absorbed. For in what post?
Jalmitrayal.
In grade 4?
Nowadays it is called Jalmitrayal.
He's asking for appointment in grade 4 post.
In grade 4
Grade
post.
4 post.
Presently it is Jalmitrayal.
Per contra, Mr. R.R. Gogoi so and so submits that the petitioner having been initially engaged by a
Water user committee.
water user committee, which is not an instrumentality of the state, the present writ petition is not maintainable. I have heard the learned counsels at length and perused the materials available on record.
My lord,
Apt to refer, initially you say that paragraph paragraph 5, paragraph 3 to paragraph 11 is reproduced hereunder of the writ petition, is reproduced hereunder for ready reference. You'll find it from page 6. The relief as prayed for in the instant writ petition reads as hereunder. Paragraph 10. Reading of the aforesaid, it appears that on two grounds, on two grounds, the aforesaid writ petition has been filed. For compensation under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2023 and Assam Land Requisition and Acquisition Act 1964 in respect of the B schedule land allegedly to have been when was given this? When this land was given? Where is the date mentioned?
1982, Your Lordship.
1982. Allegedly to have been acquired by the respondent authorities in the year 1982. And for engagement of the petitioner as grade 4 employee permanently either at Daityalbori Pipe Water Supply Scheme, Morigao District, part under Dhing, PHE Division, Nagaon, or in any other pipe water supply scheme under said Dhing, PHE Division, Nagaon. Stop. Mr. Gogoi, what is this pipe water supply scheme? This is run by the Jal Mitra Board?
Is that in this schemes, whatever we construct everything, the tanks and everything, then we give it to the concerned area. The users, they form a user committee, they appoint a Jal Mitra who is the responsible maintaining that pump, Your Lordship.
Where do I find this? Anywhere?
I have a scheme, Your Lordship.
Yes, please give.
The first point, your lordship.
Scheme of operators.
Yes,
that-
PWSs. So they are the judge meters are the operators and the volunteers, your lordship.
apt at the outset to refer to the pipe water supply scheme to which the petitioner is seeking absorption. The scheme is for selection of operators and volunteers.
At first, before that, your lordship, kindly supply drinking water, rainwater housing, water recycling.
Where do I get all that?
That second page, your lordship.
Yes.
The pipe water, that's after this supply of drinking water, rainwater housing, water recycling. Second page,
Yes, I have the second page.
the pipe water supply scheme. It starts with this order by the government of Assam addendum.
Just mark this.
Supply of drinking water, rainwater harvesting, water cycling.
Oh, this was
Yes.
this page. I was referring the wrong page.
May I read the lordship?
Yes.
The pipe water supply scheme functional in all
No,
respect are to be handed over by the PHE to PRIs.
কি বলি লিখিলা? No, the pipe water supply scheme, hereinafter referred to as PWSS, appears to be, in terms of the addendum dated 22/7/2022, that the same is functional in all respect to be handed over by the PHED to the
PRIs.
PRIs. PRIs mean?
PRI most probably panchayat most probably.
It further appears that, please find that out, huh?
Yes, sir.
It further appears that in exceptional case where 100% coverage could not be done due to geographical barriers, the partially completed scheme may also be handed over to PRI, provided at least one habitation is completed and subject to clearance by the chairman, DWSC. DWSC would
Water.
district water.
SC.
Please give me the
I'll
full
give you-
forms of all these abbreviations.
Yes,
Huh?
yes, sir, lordship.
It further appears that the Water Users Committee of the PWSS thereafter shall form or will be formed. Will be formed of dissolved or what is
Or
this?
dissolved. Or dissolved in a general body meeting.
Will be formed or dissolved in a general body meeting with a quorum of at least 50% of the users of the command area of the scheme.
If for any emergent scenario,
It further appears that if for any emergent scenario, the Water Users Committee is dissolved before completion of the tenure, the new Water Users Committee will be formed as per existing guidelines for formation of Water Users Committee.
now this is the body, the general body of the water user committee.
The general body meeting for Water Users Committee comprises of the following. A to A, from here. I think the rest is not required. Anything required?
The next page clearly says Selection of operators and volunteers.
It further appears that after the users committee is formed,
Yes.
they shall
Engage.
engage operators stroke volunteers
Yes.
in order to do the volunteer works of the PWSs. Stop. In this connection, apt also to refer to the relevant paragraphs of the affidavit in opposition filed on behalf of respondent number 5 on 1/4/2024, which reads as hereunder from para 5, page 55, to paragraph 8. Reading of the aforesaid averments, it appears that the petitioner was also engaged by the users committee as volunteer, which was constituted by the village people in the said department. Apt also to refer to the engagement letter issued to the petitioner, which reads as hereunder, quote unquote, page 78. A perusal of the aforesaid engagement letter amply indicates that the engagement has been issued by private individuals with no involvement of the state or its instrumentalities. Pertinent that the coordinate bench of this court by judgment and order dated 29/1/2025 in WPC 386/2025 has dismissed a similar writ petition filed by similarly situated persons on the grounds of the writ petition being not maintainable. Relevant paragraph of the aforesaid judgment of the coordinate bench reads as hereunder, quote unquote. A pink flag today. A to A. In the present case, it is apparent from the materials on record that the order of engagement has not been issued either by the state or its instrumentality. That being so, the prayer of the petitioner for absorption in PWSs, that's
PWS.
is purely is not within the scope, is outside, is not maintainable in the instant writ petition. Stop. As regards the prayer for compensation under so and so to likhe diba, as prayed for, the land of the petitioner's father, admittedly having acquired way back in 1982, for which there is no document on record to show that the petitioner at any relevant point of time has taken up the aforesaid issue before the authorities. Be that as it may, the same appears to be totally barred by leches.
And this land was donated by the petitioner to the authorities.
It is worthwhile to mention that the subject land appears from the materials on record to have been donated by the petitioner's father at the relevant point of time. Be that as it may, the aforesaid prayer is also not maintainable. Accordingly, with the aforesaid observation, the pleas taken by the petitioner cannot be entertained in a writ petition in exercise of power under Article 226 of the Constitution of India. Accordingly, the writ petition stands dismissed, no cost.
Either of you have seen it, District Water and Sanitation Committee.
Etu likhilo Anamika. District
Water and Sanitation Committee.
Water and
Sanitation
Committee. Etu likhilo. So this, if I can extract a copy of this in the order, isn't it? This is the scheme.
The scheme.
Ahiba might decide him quote to me.
May I present a better copy than this?
Yes, let's give it to him. Oh, good. All right.
Yes.
Dismissal.